Well, hello everyone, and welcome to Uncivil Law. As always, I hope you're having a great day. This is the legal channel where we learn from the misfortunes of others. And as always, if you're enjoying our content, please remember to subscribe. So today we're doing our weekly question answer stream. You guys have questions, I have answers. And as always, we will start with the questions on Discord from the weekly questions. So here are the questions that you guys have been asking, I believe, over the last 2 weeks. Because last week we didn't do this because I had a time conflict on Wednesday. So out of respect to Nate, we did the weekly thing with Nate on Tuesday. But in either case, we're here to answer some questions. So here's the questions that you have. Okay. On voir dire and Chauvin, you mentioned on the last question and answer about needing a larger jury pool. Yeah, so when you're selecting a jury, you have a jury pool of a certain size, and if you have a controversial case, you just expand the jury pool. What do you opine about the backlash factor? Do you think people might be afraid to answer truthfully, given cancer culture, etc.? Quite possibly, but that's what the voir dire process is for. The people are required to answer under oath in their initial questionnaire. So you get not always, of course. You don't always get a written questionnaire. Sometimes you do, sometimes you don't. Depends on the case. So sometimes you get a written questionnaire in advance. Of course, the Chauvin case does. And this one was fairly extensive. And then there's a process where the jurors are individually reviewed to see if they're suitable. So both sets of attorneys get to ask questions. And of course, all this is under oath. So yeah, some people might lie, but then of course, witnesses might lie. Anyone might lie. So, we don't really have a better answer for this other than, putting them under oath and testing them via cross-examination or otherwise. So, yeah, it's possible that they could lie, but, there's really no alternative. And I don't know that there's necessarily more likely to lie in any part of the state versus any other part of the state. So I don't know what remedy, if any, there would be for that. But yeah, more extensive, in a lot of cases, you don't ask written questionnaires at all. When you do, sometimes they're like very short. The one time I got called for jury duty, I wasn't selected because the entire panel got dismissed because the case settled at the last minute. But I think there were 4 yes/no questions. And so you just ask more questions. You ask more extensive questions. You ask longer questions. It's kind of the way to tease that out. Follow-up question. Who has access to the voir dire questionnaire? Just the court and the lawyers? Yes. Just the court and the lawyers have access to the voir dire questions and answers, and they are anonymous. So they just refer to them as juror number. So by the time the attorney gets them, they don't know whose they are. But they can challenge them for cause if they need to on the writing, and then they challenge them for cause if they need to on the oral hearing. Kratos said, I know Lori lied at some point, which makes her unreliable, but why is it unbelievable that Laura Ann was KJ's ride or die, who would say and do anything for her? And then when things got going real, she flipped sides and told the whole truth and nothing but the truth to Saltz. As the signed declaration is binding, so perhaps maybe that's why she couldn't go through, because shit got real. That's a perfectly valid conclusion to draw. There's nothing unbelievable about that. That she was lying to Brown, and when shit got real, she finally told the truth to Saltz, and Saltz was completely the truth. There's nothing unbelievable about that, but it would mean that she lied to Brown, which impacts her credibility, because she would be a liar in that situation, right? So her motives are not particularly fully relevant to whether or not she told 2 inconsistent stories to 2 different people. So what her motive was, maybe she told a lie to Brown and told the truth to Saltz, or maybe it's the other way around. Maybe she told the truth to Brown and told a lie to Saltz because she was scorned. I mean, you could come up with any scenario you want, but you don't really need to determine which is true and which not. Maybe they're both not true. That's possible, but they can't both be true because they're in conflict with each other. So they could both not be true, and because some other third version could be true, but they can't both be true. So either way, it doesn't really matter to the credibility question. It might matter to determining what is the truth. And so you might be able to determine what is true, but you still have to deal with the credibility question, which is independent of the truth. SM Sturvant Vol said, was the likelihood of Toddy Gang legal costs? 0. The American rule is everyone pays for themselves. That can be changed by statute or by rule. And there are many examples where that's true, but there have been none brought to my attention in this case for a fee shifting statute or otherwise. So, and no one's asked for costs. So, as far as I'm aware, the odds of Todd getting costs are 0. And someone said, what are the circumstances where a court order losers to pay? They'll do it sometimes in truly frivolous cases because it was never really a real case at all. So sometimes they'll do it in truly frivolous cases. Otherwise, it's by statute that it's done. What's the airspeed velocity of an unladen swallow, European or African? Thoughts on this Washington Supreme Court? This is the state Supreme Court of Washington, killing off strict liability for drug crimes. Good thing or bad thing? I think it's a good thing. I think that I think we should be highly, highly suspect of crimes that have no mens rea, no mental state requirement. I think strict liability crimes are far and few between. I can think of a few that would come to mind, mostly dealing with like pollution or imminent hazard. So an example might be you are a chemical plant and you have lots of chemicals, and if you spill the chemicals onto the ground, that's a criminal fine. And that might be strict liability because you kind of assumed the liability in the first place. And so if the chemicals get spilled, no matter how careful you are, then you're liable. That same concept, by the way, is also true in civil law, where you have these strict liability offenses. So inherently dangerous situations, inherently dangerous products. There's some exceptions to that, but I think as a general proposition, having mental state requirement is a good thing. And so I think the Washington State Supreme Court's decision was the correct decision. I think you have to have some mental state requirement, even if it's negligence, but something. I don't think the mere act alone should be sufficient in the vast, vast, vast majority of cases. Rachel XOXO said, when are you going to sort out the trolls in chat? The abuse they throw on BS makes me want to stay away. Can you get more mods to sort it out? Well, we have increased our mod policy. Our policy until basically right now has been a little bit more live and let live. And our policy now is, we've always had the rule, incidentally, it has always been a rule to be nice. We've had 2 basic rules in this chat since day one. Be on topic, and we allow a little bit of leeway on that because obviously what's on topic can get there can be some tangents. So we don't enforce that super strictly. But the be nice rule, yeah, we're going to enforce that. We're going to enforce that strictly. If people aren't nice to other people, the mods have my full blessing. In fact, my direction to time them out, and if they persist, to block them. We are not going to tolerate people not being nice to each other, and it is completely unacceptable. So if we need more mods, then fine. But that has always been a rule in my chat. And so, yeah, the moderator should time people out if they're not nice. And if they persist, they should block them because we're not going to tolerate that anymore. And maybe we do need more moderators. Thoughts on the non-Vic TCPA case published? I've never reviewed it. I probably should. I just never get around to it. There's so much law that I can't keep up. As much as I enjoy Nick's coverage, I'd like to hear an opinion from someone who isn't attached. We need to do that at some point. I don't know when we're going to find time, but I haven't read it yet. The jury selection, coming from Alexander Petrovic. The jury selection for Devik Chauvin's trial is lasting hours. I guess that's crazy, but how crazy is it? How much time is usually spent on jury selection? Not very much usually. In the usual typical case, I mean, an hour, maybe. In federal court, it's even less. In federal court, it can be very, very fast. But yeah, usually you don't spend this kind of time. It's just going on because of the nature of the coverage. So everything gets dreamed out or extended out. They scheduled 3 weeks for jury selection. Yeah, so normally an hour, 2 hours. This case, let's schedule it for 3 weeks. I told you everything got extended. SM Stevenval, would you say that the KJ Toddy ruling on jurisdiction is of average length and depth, or did the judge put in extra effort? It looked about right. I've definitely seen longer decisions. I've seen shorter decisions. The decision needs to be as long as it needs to be, and it felt, and this is more of a subjective impression because I read a lot of judicial opinions. So did I feel it was too short or did I feel it was too long? It felt perfectly satisfactory. I didn't feel like anything more needed to be said. And maybe it could have been trimmed down a little, but it said everything it needed to say. So an opinion needs to be as long as it needs to be, and I felt it was adequate. So I was satisfied by the length of the opinion. So you see opinions, sometimes they're much shorter than this. You see opinions that are much longer. It depends about how complicated it is. So I was a happy camper. Does Toddy have any grounds to appeal dismissal of jurisdiction? Of course. Toddy can always appeal the dismissal of jurisdiction. Sure. Now, whether or not she can succeed, I think she could succeed. She has plausible chances to succeed. The issue is a question of law. The issue is ultimately a question of law. And so the Court of Appeals, would be reviewing that de novo with no deference to the trial court. The trial court made its findings of fact, and the court could say, okay, all those facts are true, but we think it goes the other way. So yeah, she could appeal just as saying, yeah, you got the law wrong. I don't think it's to her benefit to appeal. I don't think it's worth the time and energy. You'd be spending a year minimum and maybe more just trying to figure out the answer to that question. It seems much more efficient to my mind to just refile the case and get rid of the issue. So if it were me, I'd just refile in Minnesota and get rid of the issue. I don't really see the point of the expense that would be involved, but that's where I sit. But yeah, she could appeal and she has decent chances. I don't know that there's any authority that would prevent the Court of Appeals from reversing, so it depends on their judgment of the thing. What is a discovery referee? As for a new judge being placed on the case and saying, but there won't be a discovery referee. Well, sometimes judges appoint someone to oversee discovery who's not themselves, right? So the judges can appoint people to help them out with parts of the case. So they appoint someone to help out who's basically acting in the stead of the judge to oversee something. So sometimes a judge will oversee discovery themselves, of course, and sometimes a judge will say, okay, bring all your disputes to this guy. This guy will solve all your problems, and then will allow appeals from that very begrudgingly. So it's basically a way for the judge to shift off things to someone else if they think they need to for time considerations. So yeah, discovery referee will typically be the judge, and sometimes they appoint someone else. And they can appoint someone else for a lot of reasons, discovery being one of them. Kratos asks, if and when Toddy files in Minnesota, do you think KJ will strike with another motion to dismiss? Oh, yeah. Yeah, of course she will. She has still every other motion to dismiss that's still valid. She could move to dismiss for failure to join a party. She'll lose. She could move to dismiss for want of diversity jurisdiction. She'll lose. And then, of course, she has all her 12b6 motions, which are still valid and can be improved massively. So, yeah, I think a motion to dismiss is extremely likely. It just gets rid of one motion to dismiss. This is not that we don't have personal jurisdiction. That issue's been resolved. Everything else has not been resolved. So, yeah, I think a motion dismiss would be extremely likely, and it's great for Brown because it means, or whoever would be representing her, because it means that he gets to correct that motion to dismiss and make it better. So, yeah. KJ has no grounds to get it moved to California. She could try arguing improper venue and saying, like, this isn't the right place for it, but I don't see that working. Like, the only reason that you'd argue venue is because if you have multiple places that have valid jurisdiction, right, then the question is which of them. So jurisdiction is asking what's possible. Venue's asking which one. So if she says, okay, I'd concede jurisdiction in California, then we have two valid places for jurisdiction, Minnesota and California. So then it would be like, which one? And so then venue is asking the which one question. And normally venue, you're saying, it's like normally it's because of convenience. The witnesses are located there. There's a lot of evidence that's located there. It's an issue of convenience. What's most convenient to not only the parties, but like everything? what's convenient to the witnesses, what's convenient to the evidence, blah, blah, blah. But in this particular example, I don't see any reason to transfer for venue. So sure, she could ask, I just don't see it working. I'm also thinking about possible connection to Swanson. The cases are unrelated. KJ can ask for change of venue. I do not see that being granted. Kratos asks, what are Lorianne's chances against Brown if she were to bring a charge against him? Odds of Toddy supporting that. For revealing emails, etc.? Hard to say. Brown tried to squeeze all the exposure of the emails into an ethics rule that allows an attorney to defend himself. She could obviously bring a complaint to the bar, and she has valid grounds to do it. I don't know what the bar would do, and I wouldn't want to find out the answer to that question. She could also sue for malpractice. Unlikely there, but she wants to bring a bar complaint. She has some grounds. Kratos asks, could the judge have dealt with the alleged incompetence of Brown? Could the next judge deal with it as a brand new slate? Oh yeah, it's a brand new slate. The next judge is not bound by anything except the jurisdiction decision. That's the only thing the judge is bound by. So the law of the case is jurisdiction is not proper in Washington. That's it. So the next judge gets to review everything else from square one. And, they could bring the motions over, but the judge probably won't allow them to. So if anyone wanted to bring, if for example, if Brown still wants to pursue his damages against Saltz, that would probably have to be brought up in an independent action at this point. I don't see the judge in this case allowing it because it's too removed from the current case. But he could. So yeah, it's a brand new slate. We get to start all over from square one. About the KJ and Toddy case, what determines which law Minnesota court will apply? The law that would apply would be the law that Toddy asks for. So if she says defamation, for example, defamation where? So if she says defamation in Washington, it's Washington. If she says defamation in Minnesota, it's Minnesota. So yeah, that would be the determination as to which law she wants to apply. And then the court would have to determine if that's correct, because which law should apply is a legal question. So the first of it goes to Toddy to ask. And then it would be to the court to determine by choice of law principles which law would apply. And those are too complicated to review. But if I would expect, the boil down is, I would expect if Toddy says, I want Washington law to apply, the court will apply Washington law. And because that's where the damage occurred, or at least theoretically. And if she says, I want Minnesota law to apply because that's where the damage was created, then the judge will grant that too. So there's a complex choice of law analysis we do not have time to get into, but I would expect that the judge will grant either Washington or Minnesota, dealer's choice. Was damage caused in Washington because Toddy lives there in Washington? That would be the argument. Yeah. So you could arguably say the damage occurred in and the corporation is, if not incorporated in Washington, because I don't believe they are, their principal place of business is in Washington, which is also a valid place. So yeah, they can say the damage occurred in Washington or the damage was caused in Minnesota, dealer's choice. I think either one we're fine. SM Sentsville says, what benefits could Swanson gain from this case, which would make him want to pay for it? I don't know. The benefits that Swanson would theoretically gain, assuming he's paying for it, for which we have no evidence, incidentally, but to distract Toddy, to consume resources, the hope of obtaining something from discovery that will help, the hope that Toddy will say something in the lawsuit that will somehow form some kind of admission that he can use. So there's a lot of potential motivations, assuming he's involved, but whatever. How could his defamation be a case for use of his contract? Yeah, it can't be of use in and of itself. It wouldn't be because of the result of the case. It would be because things that happened in the case. Toddy said something in a sworn affidavit. Things were discovered in discovery. It's a drain of resources. It's a drain of time. It would be secondary benefits that could emerge. OSU grad 95 says, hope you don't mind a yes/no patent question. Can viruses be patented? Yes, if they're man-made. Anything that's made by man can be patented. So yeah, if you make a virus, yes, they can be patented. You can't patent You can't patent things nature creates. You can patent things man creates. So if you make your man-made virus, then sure, that can be patented too. No problem. So those were all the questions from the previous chat, or all the questions from the Discord over the last 2 weeks. All right, so let's answer the questions that have come up today from the bot for questions. Andy Rants, Human Philosopher, says, why don't legislatures suggest legislation or changes to it for Americans to submit to the House and Senate? That way the public could actually register support by direct head count. Well, first of all, lawyers do. There's any number of interest groups and lobbying groups, which I'd like to remind everyone are composed of people at all kinds of levels. There's grassroots groups, there's local groups, there's any number of groups which propose legislation to get them to advocate for it, to promote it. So you can belong to a group that writes legislation and get their people involved and get them to petition for it and so forth and so on, and to influence others as to advocate it for others. So as a practical matter, that does happen with lawyers and interest groups and grassroots groups and anything else, creating legislation, sponsoring legislation, promoting legislation, advocating for legislation. Yeah, if you're thinking about something more direct than that, then of course we're a republic. So on the national level, we have a representative system. Of course, some states do allow for direct action by voters in the terms of ballot initiatives and otherwise. The degree to which that's a good idea is debatable. There are pros and cons like there are in pretty much everything else. But yeah, I mean, you can find examples of that on indirect levels all over the place, and direct levels you can find at state and local levels for sure. But the answer as to why they don't do it for a direct, because we're not set up that way as on the federal level. Joseph said, nice haircut, looking sharp. Well, thank you very much. I appreciate the compliment. Sledge and Wed said, unrelated to law personally, are you or have you ever done any gold prospecting? No. I've never done gold prospecting. I once on a field trip in middle school did some sort of rock thing where I found some amethyst and then I made it into a pendant for my mom. But that was like in middle school. So other than that, no. And it wasn't really for gold. It was for minerals and stuff. Rennie Gothenther said, is there any new filing in Dominion versus Sidney Powell? Yes. And will you be covering it if it is? If I get time. It's on my list of things I want to do. The list of things I want to do is longer than the amount of time I have, which I suppose is a good thing in one way. But yeah, I want to respond to the Sidney Powell case. I want to read this TCPA case. I want to do any number of things. It's impossible to keep up. But my understanding is Sidney Powell has moved to dismiss, basically arguing that she can't be held liable for defamation because since she was talking on opinion shows, no one should understand what she was saying to be a statement of fact, merely a statement of opinion. That argument's going to go over like a lead balloon. We can read the argument, but I'm going to just tell you no. No, that's not going to fly, but nice try. Did I hear Sidney Powell's using the Maddow Tucker Carlson defense? Yes. Is it true? Well, if it's true, yes, she's using it. Will it work? No. Because the Madison Tucker Carlson defenses, like, because they are opinion commentators, people understand what they say to be opinion. And so that was Tucker Carlson's rationale in the motion to dismiss. You know, people know us as an opinion show. We're not a news show. We're an opinion show. People know us to be slanted. So people know what we're saying is opinion. And the courts have generally said, yeah, that's correct. So they get a little bit more slack. I don't think that argument works for Sidney Powell because she's not being brought in as just any random talking head. She's being brought in as the lawyer who's representing these cases. And lawyers have duties of honesty and not to be deceitful and so forth and so on. And she's being brought in as a subject matter expert. So even if you think Tucker is an opinion person or Maddow is, you wouldn't necessarily reach that conclusion as to the people they bring on. Especially when they're being introduced as, this is the lawyer for Donald Trump in these lawsuits. That's not someone there to just offer an opinion. That's someone there who's kind of there as a subject matter expert. So Yes, they're trying to use the defense. I don't think it's going to fly. Kate Evanstrin says, is the live stream you and Nate put on every week on you or his channel? On this week, it would be on my channel. I'm pretty sure. I forget. It alternates. So whichever one it is, yeah. Where was it last week? Then it would be the opposite of that. Peggy McCauley says, question, do you think of Cindy's argument that no reasonable person would believe her claims? Do you think it will work? No. I don't think that's going to work. She's trying to argue, I appeared on opinion shows, and people know that those are opinion shows, and people know that those are slanted, and therefore people take everything they hear as an opinion, not as fact. And because I appeared on those shows, people took the things I said as opinion, not as fact. I don't see that flying. No. Joseph said, regarding gun law, there's been some terrible shootings as of late. Do you expect the Democrats to successfully put forward and pass new gun control? No, I don't think so. I don't think they can get anything past the Senate. It'll be interesting to see what happens when they hit the filibuster block in the Senate, how the Democrats react. If they try to modify the filibuster rules, as long as they can get 50 votes, so that would be every Democrat, or, as long as they can get 50 votes, Kamala Harris can break the tie to change the rules as a practical matter. This is such a technical point, but technically speaking, they need 2/3 to change the rules, but they only need 50% plus one to change the interpretation of the rules that currently exist, even if that interpretation goes completely against the current rule. I know that sounds a little bizarre, but that's parliamentary procedure for you, right? So you need 2/3 majority to change the rule. So what you do is you have a rule. This is what incidentally happened for the filibusters, how they broke the filibusters for judges. This is exactly how they did it, right? So there's a rule that basically says a senator can filibuster for anything, right? That's basically what the rule says in substance. A senator can filibuster anything. They can filibuster all the things. Great. So someone tried to filibuster Supreme Court nominees, right? And someone said, I object to this filibuster. It's not in compliance with the rules. And so then the Senate parliamentarian, who's a professional staffer, who's there on staff all time to interpret the rules as a professional, independent, the Senate parliamentarian advises the chair. And the chair then says, the rule says senators can filibuster for any reason. This would be any reason. So your objection is denied. Then the next thing the guy says, I appeal the decision of the chair. So now you take the question of what is the proper interpretation of the rules, and you submit it to the entire body. And like any rule, anything the entire body does, you only need a simple majority, right? So now the entire body interprets, what does it mean when it says a senator can filibuster anything? And then with the simple majority plus one, they say, aha, what that means is you can't filibuster Supreme Court nominees. And then the chair says, okay, the interpretation of the rule, you can filibuster anything, means you can't filibuster Supreme Court nominees. Because this is a Supreme Court nominee, you can't filibuster them, therefore the filibuster is invalid. That's how they do that. It's called the nuclear option. And if you ever wondered what the nuclear option is that they keep referring to, that's it. It's where you change the rule without changing the rule. You just change the interpretation of the rule, which you only need a majority for. So yeah, so they can change the interpretation of the rule, and yeah, you go from there. So it'll be interesting to see if the Democrats try to do that with gun control legislation. You can filibuster anything, not when it comes to blah, blah, blah. Well, the rule says you can filibuster anything. I appeal the decision of the chair, and so forth and so on. Parliamentary procedure, man. Good to know these things, right? Eledian says, do you think the Chauvin trial should have been moved out of the urban area to a less influential population, or does it harm the appearance of justice? The question would be, is there anywhere in the state that would be demonstrably better to solve the problem? So the problem is, this happened in Minneapolis. The city of Minneapolis is particularly irked. Would there be anywhere better? I'm not sure that there's anyone better. Also, it seems very true that judges very reluctantly grant changes of venue for criminal cases. It's been known to happen, of course, but usually the remedy is just get a bigger jury pool. And the only reason that you would say it is if getting a jury here would be futile to try. But would it be any more futile here to try than anywhere else? I mean, that's the question. And so, do I think it should have been transferred? I don't know enough to really answer that question, because to really answer that question, I'd have to get really deep into the underlying issue. So I'll simply say that the way that they're handling it seems to be a rational way of handling it. Spermy the Cat Negra says, what if requiring lawyers to hold license requirement to the bar to be unconstitutional when hell freezes over? Oh, I don't think so. I don't think lawyers themselves would support that, because lawyers themselves hold licenses. And it does seem to be the kind of profession that would have to be regulated. So I think granting licenses for like florists is kind of ridiculous, which some states do. But licensing, I mean, it goes to the inherent, it's even more, it has an inherent constitutional element that licensing every other element doesn't have. So I can't think of any other profession where it's true. Because lawyers are technically officers of the court. In fact, more than technically, they are officers of the court. So they're ultimately in service to the court, which means that the nature of what lawyers are is a completely unilateral judicial construct. It's not even really a legislative construct, although there might be things in law about it in the thing. But if the judiciary could have any goddamn rule at once, because this is one of those things that's almost certainly a unilateral power of the judiciary. Who should be lawyers and who not? It's one of those things that seems to be fully committed to the judicial branch. So while I think you could argue it for basically anything else, the judicial branch has a manifest interest in who has the right to practice before it and can regulate it any way that they see fit. And I'm pretty positive, if push ever came to shove, that you'd be able to overrule any legislation to the contrary. Because, of course, who would be deciding it? The judiciary. So if someone said, this statute passed is unconstitutional because it's solely within the power of the judiciary, guess who gets to decide whether it's within the power? The judiciary. Ta-da! So yeah, so the judiciary can do whatever the hell it wants, and I don't think there's any possible challenge. This violates the 14th Amendment. Who's going to decide it? The judiciary does. There's nowhere left to go. I suppose you could impeach the justices and stuff, but it wouldn't make any difference. Because a new group of justices will just be like, we are God, just like the old ones are. So, yeah, no. Kobe Johnson says, I mean, if this is in the most respectful way possible, but why does it appear as if lawyers don't want to be informed, intelligent people on juries? Jurors, I guess because it's thought that we want people who have a blank slate. I suppose it's people we want who come in with no preconceptions and are going to only look at the evidence that's before it. That's the positive version of the answer. The negative version is because people who know less are easier to influence. And we want people to be maximally influenced by our legal powers. So there's the positive interpretation and the negative interpretation of that answer. Or that question. Tony Nevis says, how long you been doing, buddy? It's been a minute. Doing pretty solid. Thanks for asking. Andy Rant's human philosopher says, when it comes to jurisdiction between two different states, does it usually fall to the state of the perpetrator or the victim? I don't understand the question. Do you mean in a civil law context or a criminal law context? In a criminal law context, jurisdiction is proper everywhere where any element of the crime happened, which can be multiple different places, in which case it's whoever gets to them first. So, yeah, that's the answer there. So if you have a crime in which it spreads over multiple different states, and usually that means the federal government can also get involved. So if you have 10 different states, or if 10 different states in the federal government who theoretically could have jurisdiction over this criminal case, first of all, they all can get a turn because they're all separate sovereigns. So theoretically, you can be charged 11 different times. So that sucks. But if you want to know who gets first dibs, whoever arrests them first. Usually, as a practical matter, the state that gets them first will thoughtfully transfer it to whatever state where the principal elements of it occurred. But sometimes states want to really have it for whatever reason. They want to be a bit of a dick. So usually states will give it to other states if where it's the principal part of the crime happened. But but if a state really wants to stick it to them, whoever gets to them first. And then everyone gets a turn if they want it. So you could be in court forever. For a civil case, it can be wherever the plaintiff wants it to be as long as it's a valid place. And then the question is the sufficient minimum contacts, which we've been discussing at some length. We know the reason we're asking that question is we know it's fair to the plaintiff because they want the lawsuit. So the question is, can this court hear this case? Is it fair to the plaintiff? Yes. Why? The plaintiff wants it. So that's easy enough, right? So then the question is it fair to the defendant? And then we get into sufficient minimum contacts, which is what this case has so far been about. So that's how that's solved. Otherwise, if there's sufficient minimum contacts in multiple places, dealer's choice. So if there's jurisdiction in multiple places, dealer's choice as to where. It's the plaintiff's call. Human Philosopher said, would it be worth having the YouTube collection of lawyers to collectively write legislative proposals? Possibly. Yeah, maybe. Probably amicus briefs would be more on point. That'd be fun. Elidian says, I look forward to the court asking this. So that why then, Mrs. Powell, if no one could find them credible, why did you file these fraud claims with courts? Yeah, that's not going to go well, Elidian. This argument's not going to fly. When the moment I read the complaint against Sidney Powell, there's times where you can read a complaint and you know the answer, and times where you don't, right? There's times where you feel a lot more confident and times where things are a little bit more iffy. So sometimes you read a complaint and be like, geez, this is really tough. This is really close on the facts, close on the law. I can't decide. It's like 50-50. It's a toss-up. Or I'm so unconfident, I don't have any clue what the answer is. And sometimes you read a complaint and you're like, oh, we're done. We're done. We can go all the way to the end of the page. I already know what the answer is. And so when I read the complaint from Dominion against Sidney Powell, I'm like, oh, yeah, we're done. We can go to the end of the page. I'm like 95% confident the answer to Dominion's going to win. I mean, I couldn't think of any argument that's going to fly. So, yeah, I think Sidney's toast. It's one of those complaints you read it and I'm like, yeah, I know how this story ends. It'd be like reading a book in chapter 1 and you know how it ends in chapter 12. Like, yep, I know how this ends already. The author didn't do a very good job of concealing the ultimate outcome. Right. And there was, I think, one more question before we get to Discord comments. Maybe 2 or 3 more. Andy Rant's Philosopher says the media and Democrats saying something isn't a fact until a court says it is. By that standard, Powell's defense would work. That's not how that works. Things are facts independent of whether the media or court says it is. The court can determine what the fact is, but it is a fact in the abstract, right? It's not like it wasn't a fact until it's determined. It's just we've now determined it is a fact. It was always a fact. If you determine it a fact, it's always a fact. It wasn't not a fact at some point, so no. MI asked, how can an employer terminate an employee that won't vaccinate for COVID? Probably. I can't think of any reason that they can't. To the best of my knowledge, I believe the U.S. government has said so as well. There's no obvious reason they can't. It's at-will employment. So the only way would be if it's somehow discriminating on the basis of protected class, but it doesn't seem obvious. Otherwise, the only other way would be is if there's some state law, which would be more likely. So I can't think of any federal law that would apply off the top of my head. But it might be the case in some state. There might be state law that would read on this that might be operative. So depends on your state, I'd say. I can't think of any federal law off the top of my head. How about for a health and elderly care environment? Yeah, I would think so. In the absence of state law. JC Mills says, I find these questions and answer particularly informative. I'm glad you do. That's the goal. The goal is to be able to answer the questions that you've been wanting to know and try to, clear up issues that are not clear. MI said, I heard it was because emergency approval of the vaccine by FDA or something. I don't think that has anything to do with it. I can't think of any federal law. I mean, I'm not an expert, obviously, so there might be a law that applies. I just can't think of one. So in the absence of federal law, you'd be looking to state law, and you might find some remedies there. Any Rant's philosopher said, if someone under contract that doesn't stipulate vaccine as a requirement, and then without a new contract, then dismiss, isn't that constructive dismissal? Quite possibly. Yeah, if you have a contract that doesn't allow for it, and they dismiss, so you'd have to have a contract, which is a bit unusual. Most people are under at-will employment, but I suppose it's possible. But if you have a contract and it doesn't allow for it, then you could have a fight over whether or not it's a fair dismissal or not. So yeah, quite possibly. Can you explain the Charleston loophole that Biden keeps talking about? I understand the term loophole differently. Well, I don't remember how the person who committed the murders in Charleston got their firearms. It's been a little bit now. But let me Google it real fast. How did he get his firearms? I don't remember. Okay, so there was some sort of background check issue. When is this? Okay. Because of a gap. Okay. Oh, I think it's because the disqualifying thing was never reported to the ATF. Okay. Okay. So the FBI didn't complete his background check within 3 days. So yeah, okay. So the FBI by law has 3 days to complete a background check. If they fail, the dealer can, but is not required to, proceed with the sale on the 4th day. And apparently that's what happened. I thought also maybe his mental health was not sent to the FBI, but that doesn't appear to be true. So the appears that they felt they did not meet their timeline for some reason. So that would be the Charleston loophole. If you can't complete the background check within 3 days on day 4, you can get the firearm. Apologize. Dealer's choice. A dealer can choose to do it. Kobe Johnson says, question, do you know off the top of your head how large civil settlements are taxed? No, I don't, honestly. Sorry. Andy Rand's human philosopher. Sorry, I'm in the UK. All employment here comes under contract. Every contract has to stipulate what breaches it one employer can do. Okay, yeah, fair enough. And then Garrett Jackson says, how's that a loophole? I don't know. It depends what you interpret as loophole, I suppose. I don't know. I told you what it is. How's that qualify as a loophole? I don't know. Depends what you consider to be a loophole. Okie doke. So those are all the questions, and we've been doing this for 43 minutes. So let's look at a few comments that are pertinent. So I have a question in my community tab. If you haven't seen it, I put a question in my community tab that said 12 Angry Men from 1957 is the greatest legal movie of all time. Changed my mind. So if you want to argue that a different legal movie than 12 Angry Men from 1957 is the best legal movie of all time, there's an opportunity to do so on my community tab. So there's been some other suggestions, obviously. To Kill a Mockingbird, A Man for All Seasons, Time to Kill, and Rainmaker. Legally Blonde, Devil's Advocate. My Cousin Vinny. My Cousin Vinny's a strong contender. All right, so yeah, there's some debate on that. If you want to have a debate on my community tab, go over to my community tab, and you also can offer an opinion. A child of the 80s said in response to Miss Haley Page versus JLM, IP and patent law, it looks as you did a follow-up but made it private. Yes, I attempted to do a follow-up last night. I made it private and then I deleted it. The reason I did is because I was getting a lot of negative feedback from the chat, And also, one of my moderators was saying that the way I was presenting the material was not ideal. So I had a thought on how to do it differently. I had to think about it, and I'll redo it. So, I have some thoughts here on some of these issues, and I was not adequately expressing. The issue I ultimately decided was the problem was I wasn't adequately explaining the reasoning for my conclusions and just stating my conclusions, which I sometimes have a tendency to do. As I was stating earlier when it came to the Dominion thing, like sometimes when I think the answer is obvious, I like to run to the end of the page. I'm like, I don't need to do any analysis. I just like to run to the end of the page. It's like I know what the answer is, right? It's like looking at a math problem and already knowing what the answer is, and your teacher says, show your work. It's like, but I know my answer. I know the answer. I just want to write the answer because I know the answer already. It's like, but I want to show you how you got there, but I know the answer. So it's that kind of thing. So I didn't show my work sufficiently. And so the chat was unable to keep up with why I was rendering some particular opinions. So I deleted the video, and we'll give it another try. We live and we learn. It didn't work out. A lot of people had negative opinions. I think those negative opinions were valid. The negative opinions were produced because I was not adequately explaining my reasoning, and we'll give it another shot. It happens sometimes, right? We live and we learn. All right, in response to Legal Eagle talking about Portland, I already subscribed to you and I threw you a like on this video. Well, thank you. I appreciate all the likes on all the videos. It's always appreciated. I like the counterbalance to Legal Eagle, who I also follow. I have no objection to you following Legal Eagle, and I appreciate that you look to me for some counterbalance. But I do have to say, as a Portlander who did not go down the protests, I found the police response more problematic than the protesters. Yes, they vandalized the Judicial Center, but those individuals can be arrested individually. It's not hard with all the surveillance in the area. Now, I'm not sure how easy it is or not, because a lot of it was done at dark, and a lot of people were wearing like all black to be harder to spot. So I'm not sure how easy it is with the surveillance, but okay. And I would say bodily harm, including some who have had permanent damage done, including loss of an eye, indiscriminately carried out by law enforcement, is disproportional to paint or fire on concrete or steel. Yeah, assuming that you knew it would stop there, I suppose that's you're the thing that I don't think you're fully considering here is what would have happened in the counterfactual universe where the police were not present. So what you're looking at is the police were present, the police took these actions, the protesters took these actions. If the police had not taken these actions, the protesters would have taken the exact same action. Or if the police were not present, the protesters would have taken the same action. So I think you're assuming, and I think a little bit falsely, that if the police didn't take the actions they took, the protesters would have stopped where they stopped. I think the protesters stopped where they stopped, at least in part, because of the actions the police were taking. Because the police were willing to show their ability to resist, because the police were resisting to the degree they were, people were disincentivized from doing more because they knew the police would fight back. I don't think it's inherently obvious that if the police had done less, you would have gotten the same result. You might have, you might not have, but I think you're not fully considering what would have happened in the counterfactual universe where the police did less. Whether it would have stopped at paint or fire on concrete and steel or not. And I don't think also, incidentally, the law enforcement is using force in response to paint and fire. They were responding more to things being thrown at them and other things. So I don't really also think that's a fair characterization of where the police were using force and not, based on my observations, which isn't necessarily all inclusive. Maybe there was more stuff I didn't see, but based on what I saw, at least. I described the protests like this to people from out of my town and could hear them from my house. There'd be hours and hours of nonviolent protests every night. One might query about why it was nonviolent in particular, though. Was it nonviolent because the protesters were inherently nonviolent, or were they dissuaded from violence because of the police presence? Then sometime around 11 p.m. or midnight, contingents of the Black Bloc Party, anarchists interested in disrupting society, more in supporting BLM, showed up and started playing a game of Poke the Bear. Okay, well, that's kind of a bad plan. The bear, the law enforcement, came out with teeth and claws on full display and in use, and as can be predicted, the black bloc gets what they wanted. Well, I couldn't really speak to what the black bloc wanted in particular, and I can't really say that their motive should change police behavior. If presumably the black, by your own description, the black bloc was going to do whatever it took to get the police to respond. So the only thing the police could do would be to never respond, which means that the black bloc could go and just completely assault police officers because they would never respond, right? That's what that would mean. So if the police would never respond, that means the black bloc would be able to, literally kill police officers because the police officers would never respond. So unless you're willing to go that far, and I don't think you should have to, at some point the police have to respond out of nothing else than self-preservation. So if your goal is specifically to antagonize the police, there's going to be a point when when the police are going to have to be antagonized, because the only alternative is, the police getting completely destroyed, which isn't good from a self-preservation perspective. So I don't know what the alternatives are. I've got several friends who were trying to leave after dispersal or were hit in the back of the head by ammunition or shoved to the ground by officers. It's indiscriminate show of force on the whole crowd that would cause public relations problem night after night. This is assuming that the police were in a position to be able to discriminate, which isn't necessarily obvious. My understanding of the dynamics of the situation were that the police were severely outmanned and outnumbered. And so the police were not able to discriminate in the use of their tactics. And even where they were able to discriminate, they weren't necessarily able to effectuate that discrimination. So, for example, if the police were firing a BB gun, or apologies, not a BB gun, but a beanbag gun or some kind of non-lethal projectile, right? If they're firing at a particular person in the crowd, if that person moves, they might hit someone else, or they might hit someone else because it's dark and they're not precise, and so the rest of it, right? So because your friends were hit doesn't necessarily mean that the police were trying to hit them in any sense. They might have been trying to use crowd dispersal tactics that just so happened to fall upon your friends because they were part of the crowd. And they might have been trying to use discriminating sort of tactics, but they hit your friend because they're trying to hit someone in the crowd and they missed, or the person moved or something. So, if you're in a crowd full of people and the police are using force, even if you're not one of the nonviolent ones, that's kind of unavoidable. I don't know what the alternative would be. Naturally, the media only covered the salacious parts and reported it as Portland being destroyed. Well, the media only covers salaciousness. I think that's fair. And also, the salaciousness is kind of the thing that is most relevant when it comes to determining how the police should respond, right? So the worst behavior, because this is kind of like the rule of why we can't have nice things in general. The rule of why we can't have nice things in general is because there's some jerk who ruins it for the rest of us. So the most salacious things are exactly the thing that will or will not justify the police's behavior. So there might have been lots of peaceful protests, but the non-peaceful part of it is the part that the police have to respond to, and that's the part that's relevant to their tactics or lack thereof. So we can analyze that and we can criticize it, to be sure, but looking at all the peaceful stuff doesn't really matter. The police wouldn't respond to peaceful protests, or at least they shouldn't respond to peaceful protests. So only the salacious parts are really relevant to our analysis. Pretty much everything was localized to 3 inner city blocks there at the Judicial Center and the court building most of the summer. The vast majority of the black bloc protesters were self-appointed revolutionaries and white punk. Again, it would not have been hard with resources at Fed's disposal to track down the particular individual. I don't think you're fully appreciating the dynamics of the particular situation at the time. I don't think if these black bloc protesters were purposely trying to antagonize police and were purposely trying to appear as though they're part of the crowd as part of that antagonism, I'm not sure what resources you think the Fed could have to track down these people in a large crowd with a dynamic moving environment where people are wearing uniform color to avoid being discovered. This is one of the things Antifa was known for, was wearing all black, so it made it harder to identify who was who. So you're at night with targets who are trying to blend into a crowd, who are trying to antagonize police. I'm not sure that there's any clear alternatives. It's not immediately obvious to me. that there were better alternatives when there's a huge crowd of people and the police are outmanned and things are being thrown at them and bottles and projectiles are being thrown their way, missiles are being thrown their way. I'm not sure there were necessarily better alternatives. Does that mean, am I saying that everything the police did was right? No, of course not. I'm not saying every single action the police took was right. I'm not saying that there weren't police actions that were improper, that can be identified as improper. I'm not saying that there were police officers who did improper things. I'm not making any of those claims. I'm not making absolutist claims. But I am saying, on balance, if you consider the whole dynamics of the situation, and you consider the resources that are available, and the potential threats of the situation, it's not inherently obvious to me the police didn't act appropriately to the situation. Did some police officers act improperly? Probably. Did they act maliciously? Maybe. Did they do wrong things? Possibly. Did the police as a whole have clearly better alternatives given the situation and the dynamics? It's not obvious to me. So that's what I have to offer on that. So there were some questions. Not legal, but I saw it asked, could cereal with milk be referred to as soup? Well, my answer there to question is, you define soup, and I'll tell you if cereal with milk is soup. That's the great answer. Define soup, and I'll tell you if cereal with milk is soup or not. Michael Onus says that's not a loophole, it's just what prevents the feds. Okay, fine. That's a matter of opinion, sure. MI says, or have better communication with the community and know who to target as smallest distributions. The feds, by their very nature, are not really community focused. That's not their job. The feds wouldn't have good relations with the community because they're not community focused. They're federal focused by their very definition. So I'm not sure that's possible, really. Michael Onus says, you also have to question whether the friends are giving an accurate account of their involvement. That's true. You also have to assume that what we're being told is an accurate description, and we don't know that for sure. MI says that the police have good human intelligence and communication. They should be able to target individuals before they disrupt. How would you do such a thing? How would you target an individual before they disrupt? For conspiracy? The problem with conspiracy is that you need an overt act in furtherance of the conspiracy. So even if you knew that people were collaborating or planning a thing, how would you disrupt them? Using what charge? I mean, if we're looking at this from a legal perspective, I'm sure we could bullshit something, but let's pretend that we're actually going to apply the law. All right, you're a police officer or you're a federal officer. You know that this person in particular has been a problem at riots in the past. Can you use that information to arrest them now? No. Why? Because it's preponderant. It's predilection of evidence, and you can't really use that. That doesn't mean they're committing a crime now. You know for a fact a group of people are talking about staging a thing at the Capitol, at the courthouse later. Can you arrest their leaders? No. Why? They're involved in only half the part of the conspiracy. They have an agreement, but they don't have any act in furtherance thereof. They don't have any overt act yet. They haven't committed any offense. What exactly are you proposing that they should do? Based on prior behavior, they should arrest them now? Based on what exactly are you proposing here? I don't quite get it. The Israelis have been teaching crowd control tactics for years. Well, the Israelis have a different set of laws than us. So the Israelis probably don't have these same laws. So I can't speak to what works in Israel or not. I can speak to U.S. law. I can't speak to Israeli law. You monitor them in real time and arrest them with undercover officers standing next to them upon the first time thrown. So your proposal is with diminished forces, because that's the whole premise of this, right? We don't have enough force, right? We only have a limited force. So your proposal is put claim close to take people off the front line and intermingle them with the crowd. This doesn't necessarily seem like the best suggestion in my mind. Doesn't seem like it'll work. Nathan Gregory says, if being sworn to in court, can one still testify if they swear a different oath? For example, tell the truth to the best of the ability instead of tell the truth. No, the oath is promulgated by law. Your choice here, you do have one choice. You can swear to tell the truth or affirm to tell the truth, which was written to satisfy, I think it was the Quakers, because the Quakers don't swear. They don't believe in swearing because there's a prohibition on it in the Bible. So you can affirm to tell the truth rather than swear to tell the truth. Also, incidentally, that's also in the presidential oath, and I believe one president did affirm to tell the truth rather than swear. And also the words, so help me God, are not in the oath. So you don't have to say those either. So those are options. But I'm not sure your solutions really work to my mind. With all due respect, am I? But maybe we just see things differently. Yeah. What about intentional infliction in response to the bar exam? We got there eventually. Go Yo Go, in response to episode number 47 of the Capitol Hill riots, said, really can't believe you've spent 47 episodes in this. Seems like there might be something better to talk about. I don't know. I think talking about the Capitol Hill riots seems like a pretty worthy subject of our intention. So I'm going to head and disagree with you on that one. Upvote for the hat. The hat should decide who will go and who will stay. Fair enough. Someone at the company pissed off a cop. That's probably almost certainly true. We don't know the backstory, but that's almost certainly true. Cowboy hat his back. It's pronounced McIntyre. Fair enough. I'm a judge and I can do a lot of shit without anyone asking. True nubs have never been spoken. Yeah, judges have a lot of power. They can abuse their discretion. So there is a concept of abusive discretion. So judges can absolutely go too far. But judges have a lot of control over their courtroom and a lot of control over their proceedings. And they can tell people to knock shit off. Now, that obviously can go too far, and it does happen, and courts of appeals sometimes reverse judges, but, I think, I mean, judges can do a lot of stuff without anyone asking. They can just sua sponte do shit because they get control over their courtroom. They've been put in a position of trust, so, yeah, they get a lot of control as a result. There is a reason that every lawyer who is sane would say that rule number 1 is don't piss off the judge. There is a reason that rule number 1 is don't piss off the judge. Yeah. The judge can do a lot of shit, and even if they can't, it's going to take you forever to figure that out because you'll have to appeal and so forth and so on. So, yeah. Pan Man is a title of a low-budget 2011 movie in which murderous Pan Man seeks revenge on a culinary professor. Okie doke. Ooh, there was a super chat. Thank you. Let's see what other super chats there were. There was a super chat of some value. It looks like $5. Says, hope you're keeping warm. I am keeping warm. Thank you. And $3 from MI, who gave me $3. Thank you very much. I'm sorry if we don't see eye to eye, but I gave you my best answers to the question for whatever value it is, and I'll hopefully explain my reasoning so that you understand where I'm coming from, even if you disagree with him. Love the logo. May I recommend making the border shiny too, like the graphic? May I recommend making the border shiny like the graphic? The orange thing, I kind of like it the way it is. Also, that's Clemson orange. So I know there's not much of it, but that's Clemson orange, and so no. I kind of like it. Here for the beauty, fashion, influencer content. Yay for IP law. Are you sure you know what a bridal dress is? Are you really sure? Yeah, that was a question I raised in the chat, right? Because if you're limited to designing bridal dresses, the question is, what is a bridal dress? It's like, are you really sure you know what a bridal dress is? It's like, when you think about it, right? So, yeah. Okay, what about conspiracy to commit murder by poison? I'm not really seeing the violent physical force. Then I don't know what to tell you. You can't see the violent physical force in a murder by poison. Okay. I got nothing on that one. It would be ironic if they sent that wire to California and some background drama of why Texas is really trying to stick it to New Mexico. Yeah, there could be something there, yeah. A few other chats come in. Check out Wiki on Mista Avram, if time allows. Nathan Gregory, if that's the case, if one does take an oath, but it's found to have been total falsehood, is it considered a lie even if it's unintentional? No. For something to be a lie, it has to be knowingly a lie. So if you say something that's false, the difference between a lie and a falsehood is intent. Something can be false and not a lie. It only becomes a lie if you intend it to be. So yeah, you have to knowingly tell a falsehood. So if you tell a falsehood and you didn't know, it's not a lie. So no. Andrew, human philosopher. Apparently, cold hot chocolate with chocolate chips is a dessert soup. So technically, okay, so this is your definition, right? A soup is any liquid with a dissolved protein or plant matter. So yes, cereal with milk could be a soup. Yeah, on your definition, right? Cody Sam says, forgot stopping the coverage. I want the opposite. With the slowdown, we need riots and review where you break down how many people on charges came with the whole thing. As time allows, my friend, as time allows. JC Mills says, I didn't realize how subjective the law is before watching your channel. Well, at the core of law is philosophy. It's applied philosophy. Because at the core of law is the question of what should be. You could have a dispute between any two people. Like, let's just make up the most silly dispute possible, right? For person A punches person B. Person A sues. Who should win? Now, you might think that's silly, but it's like in the abstract, we could have any rule, right? So we could have A should win because A is suing. Now, listen very carefully to what I'm saying. A should win because A is suing. That could be a rule. So that would mean anytime anyone sues anyone, they win. Or B should win because they're being sued, which would mean that no lawsuit would ever be successful. Or person A should win because they're taller. Or person A should win because they're female. Right? So I know these are somewhat silly examples, but the point is to illustrate that you could theoretically construct any number of rules. Right? And so at the core of law is a question of what should be the rule. And there's tension there because there's a lot of competing priorities. And one of the things I like about law in particular is I find it to be kind of the story of the human experience distilled. The law, especially laws that have been around a long time, have survived as long as they have because there's something at their core that's true. They have survived generation after generation because something at them is correct on some fundamental level. Or they would have been changed long ago, right? So there's something in there that's in some sense true. That isn't so much an appeal to tradition, by the way, as an appeal to survival. You know, because people changed the law, because it survived so long, suggests that maybe there's something there that's valid. So that isn't because it's old, it's true. It's because it survived this long, it's true. There's something there at some level that must be true. You know, the gate is in the field for some reason. No one builds a gate for no reason. So I like law because it's a practical philosophy. It's the story of the human experience distilled in, like what should be and how do you perceive things? And what are your values? And there's really no right answers to some of these questions. And it's kind of due to your subjective preferences at some level. And the law is the accumulated opinion of everyone as to what the rule should be. Or so I see it anyway. So, for whatever value that has. Were there any new FBI arrests? Oh yeah, the FBI is arresting people all the time. And also I haven't caught up on all the things. So yeah. In response to episode 44 of the Capitol riots, I initially wasn't interested, but the way you present it is humorous. I'm thoroughly enjoying it. Thank you. I like your gloating. It's not vicious, just having fun. We gloat from time to time. Let's not pretend we don't. Yeah. I think the people who are sad at me gloating were the people who were sad at being wrong. That's my working premise. I like your perspective from the get-go. I feel more inclined towards it. It turned out the judge has a similar way of thinking. Yeah. It's nice when your thinking tracks the judge's thinking. I'm like, we're on the same exact page. I didn't think I'd win, right? So I predicted against what I wanted because I was trying to be fair, right? So I was trying to be as objective as I can possibly be with my own biases. And so I predicted I wouldn't win. I predicted my view wouldn't take the day, but when my view did take the day, I was pretty damn pleased. I was like, wow, maybe I should have more confidence in myself. Maybe that's the lesson at the end of that. Maybe I should have had more confidence in my prediction. But I was trying to account for my own biases. So maybe I overcompensated. I don't know. Which it makes it all the more frustrating, incidentally, when there's people in that discussion about Toddy without a crystal ball who keep insisting, you're so biased, because I make a very conscious effort to try to account for and correct for my biases when I'm scoring these things. And I also know the difference between what I want the law to be and what I think the legal result is going to be, right? So I try in every way I know how to compensate for my biases and I don't confuse my own thinking with what I think the court's thinking is going to be. And there can be divergence, as we saw in Toddy. So it makes it all the more frustrating for me when people keep saying, you're so biased, because I make such an effort not to be. And then one person in my comments was even teasing me because I was technically wrong, right? It's like, well, the judge adopted your thinking, even though you're technically wrong because you didn't think it would happen. I was like, I cannot win with these people. I cannot win. It's like, I predict against myself because I think I'm going to be proven wrong, even though I want to be proven right, obviously. And then having predicted against myself, but ultimately being vindicated because I ultimately was right, I get teased for not having predicted for myself in the first place. Like, you cannot win. You just cannot win. And it's very frustrating. It's like you make every effort to be as honest a broker as you know how to be, and you cannot satisfy people. It's frustrating sometimes. Michael No said, I appeal the decision on one of Bryle addresses to the chair. There you go. Padre Mike McCulley said, I agree with your statements with regard to cops when outnumbered, but if they've been charged with previous offense, can't be made as part of the terms for bail of an exclusion order. Sure, absolutely. Yeah, as part of, it is very, very typical that when you're on bail or probation, that one of the conditions is that you not commit new criminal offenses or that you not be involved with stuff. So yeah, it could make, if they've been previously convicted, it could be made a term of their sentence. But in the absence of that, it can't be done in the abstract. So yeah, as part of their sentence or part of the court's order, sure. But you can't do it otherwise. And someone asked about new FBI arrests, and I think I answered that. So, in response to episode number 47 about Ethan Nordo, aka Rufio Panman, Bongo says, dude is a Fed. So is Biggs. Wake up. So Bongo Suvio over here is of the opinion that Rufio Panman, the sergeant at arms for the Proud Boys, and Biggs, who I forget exactly what his title was, president of his chapter, maybe. Bongo is here of the opinion that Biggs and Rufio are actually federal agents. I'm going to press X to doubt on that one. So I guess I will have to remain sheepishly unawake on that one. Not buying that. No. Kurt popping bubble. Yeah. Not the hair of the dude in the left corner. Yeah, I couldn't figure out exactly what it was pointing to, so apparently I picked the wrong person. But then again, the arrow might not have been clear, but whatever. Thank you for making these. It makes my day. If you ask a friend to mind an old cat and it dies, suing is just a dick move and just as practical. Yeah, especially if your friend didn't have anything to do with the manner in which it died. Philly James said, in response to me saying the law applies to everyone, he says, that's the funniest thing I ever heard. The law applies to everyone. Yeah, okay. Well, the law attempts to apply to everyone. That's the point. Equal justice under law. And what makes someone equal is complicated, because that's part of the struggle of law, is what equal in what respects. And so you sometimes have different laws applying to different people because we have to judge what makes them equal. But then you say all else being equal, right? So you have to decide what's important, what's signal and what's noise. So you can lawfully, and this is 14th Amendment valid too, you can lawfully discriminate for reasons that matter. And then the reasons that don't matter become noise. So for example, just to pick a really arbitrary example. Can you think of an example where it's lawful to discriminate? Sure. Person A punches person B. We're going to put person A in jail, not person B. And we're discriminating. To discriminate, it just means to choose or to separate. Discriminate just literally means to make a choice or to separate from one from another, right? So person A, person's B. We are going to discriminate against person A by putting them in jail, right? So why are we doing that? Because person A punched person B. So our point of discrimination is the physical violence in this case, right? We've decided collectively as a society that if person A punches person B, we're going to put person A in jail. So we've decided collectively that punching someone in the face is a valid point of discrimination. And then we've decided that everything else doesn't matter, like if they're taller or shorter or blah, 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 you fill in the blanks, right? So yeah, what makes someone equal? So what would make someone equal in this hypothetical is everyone who punched everyone else in the face. And then we're like, well, what about self-defense? Okay, well, now that's something else we have to consider. What about justification? What about this? What about this? What about this? And those are new things we have to consider. With new things we have to consider, and we add to the complexity. But at the end of the day, once we've done all this complexity, whatever else doesn't apply, everyone is equal, right? That's the idea. And the law struggles with this, but I think mostly it does a pretty good job. And it's not perfect, and it's not to say it can't be improved, but it tries. So yeah, the law applies to everyone. It doesn't apply to everyone equally all the time because the law just simply doesn't apply to everyone all the time equally. I haven't punched anyone in the face today, so the law dealing with me punching people in the face doesn't really have any immediate applicability to my life. That law does not apply to me today, and that's a good thing. Yeah. I would argue there's no such thing as a consensual or voluntary interaction with police officer acting in an official capacity due to coercive effect. People don't worry they'll be arrested for ignoring a random person or asking them questions. That's a perfectly valid policy position. I won't argue with you as a policy. I don't think, as a practical matter, people feel equally free to refuse the request of a police officer versus someone else. And so I think you have a perfectly valid point. Now, if we were going to go down this road as a society where we're going to argue this, we'd have to conjure up the new rule. So we'd have to think about what that would look like. But it's a perfectly valid policy perspective. I won't argue with you there. In response to number 47, I disagree with you on the evidence bit, but you're correct on the ruling, so it's moot. I don't know if they're responding to that or not. Looks like it's about 50% of states, something like that. I'd be proud to if I delusionally believed that I was responsible for the modern world. I mean, I haven't done shit in my life compared to creating the Western world. I probably feel entitled to a week off after that, but I'm smart enough to notice the world was here before I was born, therefore I didn't create. That's funny. I like that very much. That's cute. You shrunk. I was playing with the distance from the camera. Yeah, some people thought I was too close to the camera, and so I was playing with distance to the camera in that particular episode. And I decided I didn't like it. So I decided I liked this framing. So you guys can let me know whether or not you think this is too close or not. But I kind of like this framing, so I was playing with it further back to see if I like the framing. I concluded no. But yeah, I did, in episode number 46, I filmed it further back because I wanted to see how it looked. I decided I didn't like it. Anna said, please don't ever change. I love your sardonic, witty, completely unimpressed vibe. Thank you. That's very kind of you. Come on, browser. This is the part of the exercise where my browser starts lagging. In response to episode number 46, I'm looking forward to watching this episode as well as others released on the same day. As someone who lives in Australia, I'm fascinated by the series as well as I still can't believe how low people can go. Oh, that was expanded. I just don't get the MAGA loonies and find it so hard to understand how so many people can be misled by Orange Little Baby and QAnon. I think it says a lot about states. I don't really think this is a uniquely American problem. I think there are probably just as many batshit crazy people everywhere. Maybe society has a better ability to restrain them or something, but I'm not 100% sold this is a uniquely American phenomenon. Thanks for the hit. Another nice compliment for my haircut. Appreciate that very much. My hair was getting very long. I was very happy to get it cut. That was really nice. Legal is such a worm. I love My Cousin Vinny. My Cousin Vinny is a great movie too. We should have a poll in chat. We should have a poll in chat. Let me just create a poll real fast so I can see. Hold on. I'm just going to create a poll in chat. Have you seen A Few Good Men? This is 1957. We'll just say yes and no. It's easy enough. All right, so I'll just create a poll real fast, and I'll put that in chat. I'm interested to see if you have seen the movie A Few Good Men or not. So if you could please go to that link and enter your vote, I would appreciate it, just to see if you've actually seen the movie. And if you haven't, it's such an interesting movie, the way it's filmed. Like, the movie is about, I think, 150 minutes long, and 147 of the minutes occur in one room. It's such a great piece of direction and directing, because there's a little intro scene at the beginning where the jurors are in the courtroom getting their last instruction, and there's a very, very little end scene after the jury's done, and there's also a very minor scene that occurs in the bathroom of the jury room. But like almost 98% of the running time occurs in one room. There's no special effects. You know, there's no one's playing with anything in the room. It's basically just 12 people sitting at a chair and talking. And it's amazing. It's so good. It's so good. And no one's really doing anything. No one's performing any action. There's nothing happening in the room. No one's moving. I mean, people are moving around, but not really. All the filming is occurring basically in one room. And it's just people talking for 98% of the movie. And it's unbelievable. It's so good. So good. It's one of my favorite movies of all time, man. See what the votes are so far. We got no votes for my poll. No one wants to vote in my poll. What did I say? Oh, yeah. I asked the wrong question. I'm sorry. I did ask the wrong question. Hold on. I asked the wrong question. I had A Few Good Men I don't like. I asked the wrong question. I'm sorry. Have you seen 12 Angry Men? 1957. Maybe that's why I have no answers on my poll, because I asked the wrong question. Yes. No. I don't really like A Few Good Men. I don't think it's that good a movie, which is funny that it was on my mind for some reason. All right, let's try a better thread. There we go. Let's try that again. Yes, have you seen 12 Angry Men? Yes or no? Let me know. I'll be interested to see what your results are. It's so good. If you haven't seen it, you should. I think it's free on YouTube. I think there's a free version of it on YouTube with ads. So you don't even have to pay anything for it. You just have to watch some ads occasionally. And I'd watch it again. I wonder if I can like lawfully stream it or something. That'd be great. And we could just stream it and watch it together. A few good minutes. So good. I guess it's very pleasant scenery if you're water. Yeah. That was a funny joke. I enjoyed that. They need JG. They need JG Wentworth. It's my water and I want it now. Call JG Wentworth. 87755. Yeah. It's my water and I want it now. Response to legal. Great job on civil. Thank you. The Texas AG reads as kind of a dick. Yeah, I don't know I don't know why the Texas AG. And it probably wasn't the Texas AG's call, although I don't know for sure. Usually when a state is suing, it's usually the Solicitor General. It was interesting when Texas sued everyone for the presidential election because it was the Attorney General who sued, which is a bit unusual. Normally it's the Solicitor General, so I'm not sure why the Solicitor General had to bug up their ass, but apparently they did. And Tubi has it for free. You should watch it. It's so good. It's just people talking for like 2 hours. I feel a huge Legal Eagle, Toddy Westbrook, Taylor Swift crossover. In response to my water video, which I thought was actually a really good one. I really enjoyed filming it. That was so hilarious. I didn't have an idea such arguments happened. That actually turned out to be better than I thought it would be. You know, when you're normally thinking water dispute, you think boring, and that episode turned out to be really good. So I think it was really nice. Am I not getting any votes on my poll? Why is my poll not getting any votes? Well, if you haven't seen it, go see it. Come on, this is where the browser again lags. Come on, browser. Come on. I'm trying to respond to comments here. I'm doing a little Q&A response to comments thing. After a long day in the welding shop, I enjoy hearing how bad of a lawyer Legal Eagle is. Too bad his viewers are too stupid to realize he isn't smart or right. I missed hearing your voice as I didn't watch the videos in YouTube drama, or I think that's what it was. Yeah, well. The drama isn't for everybody, that's for sure. Your poll is sending out 4 links at the same time. I sent out 4 links at the same time. Yeah, I sent out 4 links to make sure people saw it. It's the same link 4 times, hopefully. I just spammed it because I can. Any of the links should be equally fine. Like my haircut. A lot of people digging the haircut. A lot of compliments over the haircut. Thank you. Give you that full haircut glory so you can see the haircut. I think it worked out pretty well. Thank you very much for all the nice compliments on the haircut. Go Kurt. Legal Eagle is actually the first law tuber I followed for commentary a couple of years. His takes in politics are way too biased. Eventually found the corner of YouTube throughout the Without a Crystal Ball drama. Yeah, the thing also that I think really separates me from Legal Eagle is I make a point of pointing out my biases and trying to correct for them, which Legal Eagle has never done any of those things. This isn't to say that I'm infinitely self-aware, incidentally. I'm fully aware of the fact that I am trying to observe my own biases, which is kind of inherently impossible on some level, because I'm biased in that very observation. And so, like, there's some inescapable part, but I try. I give it an effort, man. $5 from Isaac Costello. Why is Legal Eagle in his feed? Why? I restate the question posed to you and Nate. How does it feel to be a better lawyer than he? It feels damn good to be a gangster. Damn, it feels good to be a gangster is what I'd say about that. In response to Without a Crystal Ball, I do like how you explain this. My question is, knowing how Toddy has a lawsuit with her business partner, would you recommend Toddy go ahead with another lawsuit? Would I recommend Toddy go ahead with this lawsuit? Based on what I know right now, I'd have to say no. We never really got too deep into the merits of the lawsuit, but based on a superficial reading, I don't think Toddy has a winning case, based on what I know. Now, if she wants to bring in some sort of Minnesota-specific cyber harassment thing that I don't know about, then maybe. So maybe she's got some sort of remedy under Minnesota state law I don't know about, or maybe the defamation law is a little bit more favorable or some way. But based on what I know right now, I don't see defamation working. IIED is an audit. IIED is a loser. You have to try really hard for IED, and you're not there. NEID, maybe, but the thing is, the defamation is kind of killing the whole cause of action. So in the abstract, NEID maybe, but in this lawsuit, And then civil harassment kind of goes against the very the civil harassment thing that she tried kind of goes against the very defamation claim she's trying to bring. So the only thing left she has kind of sitting is kind of residual NEID, and maybe for James, maybe not for Toddy, but maybe for James, maybe. But I think the problem with the lawsuit and the way it's constructed is I think if the defamation falls, I don't think the court is particularly eager to hold on to whatever remnant, since the defamation is such a huge part of the case. So the way I sort of saw it is like if the defamation falls, I can't see the court going out of its way to keep anything else going. So yeah, I don't think personally I'd recommend she sues. I don't really see any great options for her based on my current understanding of the situation. Now, that being said, however, I would like to qualify that because I never got super deep into the things, into the specific statements, and they did charge a lot of them. So it might be that there's statements there that could survive, and maybe I'm being a bit unfair. So I'm open to being corrected, but based on what my superficial understanding is right now, I don't see anything working. So, yeah. Thank you for the updated current events, pun intended, possibly forced. It looks very, very forced to me, yeah. Law can't be emotional. Emotions are easily manipulated. Just look at the current political atmosphere. All emotion, no realism. Yeah, law tries to be very detached, for better or worse, and I think it's probably for better. Laugh too hard at the story your point joke. I was proud of that joke too, because it came up with spontaneously. Lawyer threatening a lawyer's family over drama. Yeah, I don't understand completely what it is with people threatening the lawyers in the Without a Crystal Ball case. And there's new threats against Salts. Some very dark ones, incidentally not well spelled, so I'm not sure how serious we should take them. But there's some pretty serious threats on Twitter. I mean, the way they're being phrased. We know where you are. You thought last time we were bad. This was nothing. This will be 100 times worth. We're ready to roll. What is your problem, people? What is your problem here? Jeez, Lord. I mean, even if you were supporting one creator or another, do we really have to resort to the death threats level? Even if you don't like the lawsuit, do we really have to go to death threats level? This is a bad law. This is a bad lawsuit. You should be ashamed for filing it. Maybe. I am going to hurt you and your family? Really? Over this? How deep are we into these circles, man? How deep does the Without a Crystal Ball circles go? I mean, come on. Let's have a little bit of perspective here, people. Yeah, Texaco versus New Mexico. I did misspeak it. I did say Texaco. I said it more than once in that episode. I'm not sure why, but I said Texaco. Slip of the tongue. I think I did 2 or 3 times in that episode. Kind of hoping no one would notice, but you noticed. Thanks for watering this down, Kurt. Cute. High school football is huge in Texas. This I know. I'm not sure why it made its way into a legal opinion, but yeah. Family law is absolutely disgusting. I can confirm those 85% of women who win are not always the best situation, far from it. Yeah. So in a divorce case, the woman wins custody about 85% of the time, which doesn't seem like that can possibly be like the correct answer, right? Because the The correct answer is what is in the best interest of the child. That's family law. Family law is easy in some ways, I guess, because it kind of has one standard. What's in the best interest of the standard? Best interest of the child. Now, it's a bit of an overstatement, but not by much. So family law, especially in like divorce and custody cases, kind of boils down to what's the best interest of the child, like 99% of the time. There's a little bit more there, but not much. So it seems a little bit unlikely that the best interest of the child can really be the mother 85% of the time. That seems a little bit, I'm not so sure. It seems skewed. So it seems a little odd that the father would be unfit that much. This is one of your best reviews for the water one. I thought it turned out really, really well too. You're in Austin now. Learn how to pronounce Del Rio. I'm not sure why I mispronounced that. There's no reason I should have mispronounced Del Rio. I know how to pronounce Del Rio. I don't know why I mispronounced it. Sometimes I mispronounce things. I don't know why. Have mercy on me, I guess. If you're gonna start criticizing me over pronunciation, man, you know. People are allowed to be shitty. It's within their rights. Yeah, people are allowed to be shitty to other people, unfortunately. People are sometimes shitty to me. And people are shitty to you. But not in my chat. In my chat, at least, I can exercise my law. My law is being nice to each other. So if you're shitty to chat, you can't be shitty to people in my chat because my mods will time you out. You do not have the right to be shitty in my chat because it's my chat. So it's one place where we will be nice. The sarcasm is strong. I do like this. I do like the sarcasm. I do like my sense of humor. I don't know if that's a silly thing to say. I like my sense of humor. I'm not sure everyone necessarily likes their own sense of humor, but I do like my own sense of humor. It makes me laugh. So, I like it. And it's not necessarily good for everybody, but it works for me. It makes me happy. You sound so much better. It's good to see. Some days, man, some days is better, some days is worse, but we do what we can. Don't forget, as much as people can be straight up dicks. Yeah. Some people care as fellow humans and wish you well. Did my heart to see you good on your game with smart mouth and positivity. Good to show, old man. Yeah, you know, it's interesting because Jordan Peterson once commented about the same phenomena on a episode with Rogan, the Joe Rogan. So he commented that when he was on Twitter, because he got off Twitter for this reason, that the vast majority of comments were positive, but he had the tendency to focus on the negative ones. And he tried to figure out why that would be. It's like, because maybe the negative comments are representing threats or something, or in real life, if someone's negative, maybe it's something for you to consider. But yeah, I've noticed the same tendency. Like the overwhelming majority of comments are positive, but I have a nasty tendency to focus on the negative ones. So maybe it's just part of the human condition. I don't know, but I do appreciate all the love. And I appreciate all the positive support because, you know, I do need it in my life. So thank you very much. Yeah, Christina points out some days you can sneeze and someone will get offended. Yeah. Answering this weird 2019 question. Uncivil Law genius. I enjoyed watching this breakdown. Amazing. I did finally get to all the things. I was late on the game with the IED and NEID, but I did finally get there. And then my immediate reaction to this question is tort? Yeah, what is a tort? It's just any civil wrong. I'm not sure. It's from French. What does tort literally mean? I forget. Does it mean harm or injury? Something like that. What does tort mean in French? Or what does it mean in English? The case dismissed. This is my favorite video. I despise KJ and Uncivil spot on. I was ultimately right in the end, so it's nice. That part about rubbing it in the face of the haters montage, I did really enjoy rubbing in the face of the haters. And then there were haters in my chat trying to bring it down that day, and I was in no mood. It just gave me more things to harass them over. It's like, yeah, and people mean in my chats, like, cry for me, man. Yeah, Abby says it was Rikita who was also talking about it. It's a human thing. Yeah. So tort just means wrong or error. Yeah. Yeah, that's right. So, yeah, it is a human thing. It's a little bit hard sometimes. What happened to the package? It's the question Ohio should have asked. What's in the box? What's in the box? I'm 627. I'm guessing the thief is the delivery man. We probably should have put in, if we really wanted to go for bonus points, although it's not really called for by the question, because, well, we could have done a trespass to chattels thing, because maybe it was the neighbor trying to recover their own chattel. So we did miss one. Even in the end, we finally missed one. We could have done a trespass to chattels analysis, because we never determined whose box it was. So if it was thief's box because it was misdelivered, and thief was trying to recover their own box, then everything that mom did over here was a trespass to chattels. So we could have thrown in a trespass to chattels. So that makes like 8 causes of action. So what did we finally wind up with on that question? We wound up with a pure battery, a pure assault, a battery plus assault. Yeah, a pure battery, a pure assault, a battery with assault. Yeah, so we had a pure battery when we threw the stapler at his head. We had a pure assault when we came out with the gun pointed at him. We had a battery plus assault when we shot him. We had a... Then what happened next? We had false imprisonment for keeping him. We had intentional infliction of emotional distress, negligent infliction of emotional distress for laughing at him maniacally for 20 minutes and mocking him with a gun point at his head. And then we could also throw in a trespass to chattels. So we have like 8 causes of action flowing from this one problem. There's probably something else I missed too, man. It never ends, man. The whole walking through the precedents was excellent. Yeah, I really enjoyed that Derek Chauvin, George Floyd third-degree murder case. I'm not sure how much everyone else enjoyed it, but I really enjoyed it. Because trying to figure out whether or not third-degree murder flies and really like get to it and really go into the depths of it, I'm like, yeah, the trial judge I think is making a mistake. I don't think you can charge Derek Chauvin with third degree. The state prosecutor disagrees with me, and the judge apparently disagrees with me. So the prosecutor and the judge disagree with me, but I'm looking at the law and I'm reading it. I'm like, no, I don't think you can do it. I don't think it works. So, the nightmare scenario is the jury convicts on third degree and nothing else, and then we have to find out whether or not the conviction's valid or not on appeal. Oof. That's the nightmare scenario. They convict on third degree, they acquit on everything else, and now we have to find out if I'm right or the trial judges are right. Is the prosecutor and the trial judge right, or am I right? We won't find out we might find out the answer. Like, if they convict on a whole bunch of stuff plus third degree murder, we might find out the answer, because they'll still appeal his third degree murder sentence, and it might get overthrown, but he'll still be convicted on other stuff. So it might reduce his time dramatically, but it won't be quite the blow. But if he's convicted on that, nothing more, we're going to find out if I'm right or if the prosecutor and the trial judge are right. Who is smarter on Minnesota law? Who is smarter on Minnesota law? The prosecutor who is in Minnesota, who works in Minnesota as a criminal lawyer in Minnesota, or the judge who is a Minnesota judge and does nothing but Minnesota law all the time? Is it these two people who do nothing but Minnesota law all the time, or me? I still think I'm right, man. I know that might seem a little unhumble, but I did the best analysis I did. I looked at the analysis and I'm like, I don't get there. So Nick Rikita also incidentally disagrees with me. So Nick also disagrees with me. So it's Nick, the prosecutor and the trial judge, who disagree with me. Maybe one day we'll find out which of us is right. These three, also, it should be pointed out that Nick Rikita is a Minnesota lawyer. So I got a Minnesota lawyer and a Minnesota prosecutor and a Minnesota judge all telling me I'm wrong. Still think I'm right, though. May seem a little unhumble, but I looked through the analysis, man. Replay crew here. I always thought your commentary was fair. Never took it as biased or being on our side. You just want to stay within the narrow confines of the law and not engage in your personal commentary or title lies. I respect that. Thank you very much. Yeah, deck is stacked against me. Yeah, deck is stacked against me. So she shot him with privilege. She shot him with justification would be the better way to phrase it. What could the stapler to the head represent? I don't even understand this question. What could the stapler to the head represent? What do you mean, what does it represent? It doesn't represent anything. It's a stapler to the head. What do you think? What are you asking? What does it represent? What are you talking about? What is this question? Can I cover the Stephen Avery case? Add it to the long, long list. I missed trespass to Charlie, yeah. Could Tardy argue she was harmed everywhere? Technically, probably. Anywhere she has, yeah, possibly. But it's probably not enough to be sued anywhere. Anyways, my browser's fighting with me and is not scrolling anymore. So I'm not sure why, but my browser's scrolling with me. So that's the end of reading comments. Any chance you could cover the Theranos trial? I think it's in 3 months or so. That might be fun. So how she defrauded people for like $5 billion. Yeah. AC said, sorry if you already answered, I just joined. What was the Haley Page video you put in private? Yeah, I answered this already at the beginning, but I'll answer it again. It was put on private and then I just straight up deleted it. We attempted to do a video response to Haley Page's answer and counterclaims, and it just didn't really work out. There was enough commentary in the chat, and one of my trusted mods texted me as well and told me that I was not being well received. So I put it on private and thought about it for a little while, and then I deleted it. And I ultimately concluded that the reason that I was not being perceived well is because I was stating my conclusions without stating my reasoning. So I was saying things like, I was arguing that things were or were not like sexual harassment, but just saying it without providing my reasoning why, and didn't provide enough rationale. So that was my conclusion in the end. So I'm going to redo it. Maybe I'll do it tonight, but I'm going to redo it just because it didn't work out. And sometimes it doesn't work out and we live and learn. So we took a look at it and it's like, yeah, it didn't work out. We'll try again. So it won't be a first react. So that's negative, but you know, what can you do? It doesn't always work out every time. Sometimes the video doesn't work out and you got to try again. When you're getting a lot of negative feedback and people you trust are telling you it's not coming off well, it's time to cut your losses and try again. Garrett Jackson says, what software are you using live to switch your video? In this particular instance, I'm using OBS. When I have a guest on, I'm using StreamYard. But when I'm just doing it myself, I'm using OBS. It seems to be good enough. So, you know, yeah, so that's all that stuff. Yeah, and so so OBS allows me to film it. And Michael Roberts says, personally, I liked it and agree with your reasoning. I think I could do better. So I think I could do better, so I'm going to give it another try. So that's all I have to say about that. But I appreciate this Q&A. We will be on tomorrow with Nate. I forget if it's my channel or his, but we'll be on tomorrow with Nate. Is there something NM in? Yeah, no. So it seems all good. I'm going to sign off. Haywood says, the odds are against you, but those odds are like I'm putting money on you, sir. Thank you very much. I mean, I did the best deep dive analysis I could do. And I'd be a fool to think that the prosecutor didn't do as deep a dive analysis as me. I'd be a fool to think the judge didn't do as deep a dive analysis as me. So the fact that they are Minnesota lawyers and they looked at it, hopeful, I mean, if they have any sanity at all, especially the prosecutor, because there's so much on the line. The prosecutor could be blind. The judge should be well incentivized, though, to not get this wrong. So, man, but I assume that they did a deep dive, and the fact that they looked at it deeply and they disagree with me, but I did as deep a dive analysis I could do. I don't know, man. I don't know. We'll see. But anyways, I'm going to sign off. Remember to like the video on your way out, please. Remember to subscribe if you haven't already. Join the channel for 99 cents, all the good stuff. Till later, my friends. I hope all's well. Cheers and goodbye.